malice that it would take to set a fire in the bedroom where the child is in the crib sleeping. A burn pattern that goes from underneath that child towards the door of the bedroom. That is caused by likely something. It's a significant burn pattern as he described it. It could have been alcohol, it could have been something else that gets consumed by the fire. But a significant burn pattern shows that there is something set significant.
Assalamualaikum warahmatullahi wabarakatuh. Hi friends, my name is Meinita Asti Lovitasari from class K1, Love Study Program at Tidar University, Magelang. Here, I will present an interesting case in my opinion. This case comes from the United States, where there is a child named Matt Morgan who has autism, but he was sentenced to a very harsh sentence of 30 years in prison for being found guilty of the murder of his half-sister. Are you curious? Let's see! So, in March 2015, in California, America, a fire broke out in the Meinita Hill home where tragedy killed her son, who was only 17 months old. When the fire broke out, Meinita Hill and his wife were not at home. They went and left the baby with 17 years old Stephen Jacob Matthew Morgan. Police officers who were on patrol saw the fire and called 119. Shortly thereafter, firefighters came to extinguish the fire and tried to save Joshua Hill and poor 17-month-old baby. However, it failed. So, then why is Matt Morgan the one found guilty of this case? Because according to the court, only Matt Morgan was in the house at the time. And when the fire broke out, instead of helping Joshua Hill, he came out and saved himself. In addition, Matt Morgan was also accused of deliberately lighting a fire to burn his house. Yes, although initially Matt Morgan denied the accusation, he finally admitted. Did he admit that he was forced? I have no idea. During the trial, Deputy Attorney Willie Thompson stated that Morgan had an interest in fire. According to Thompson, Matt Morgan deliberately started a fire in his house. That statement was also agreed by the prosecutor, saying that Morgan had met two husbands at the time, namely in Joshua Hill's bedroom and in the living room. Otherwise, at the time, Matt Morgan lit a candle to burn his house. However, Matt once again dismissed the accusation that he deliberately killed his brother. Even Matt Morgan said killing him is tantamount to killing part of me. Matt's parents are certain naives. They didn't even believe that Matt would have the heart to kill Joshua, because they are the parents of this children and they know that their son, Matt, really loves his brother. However, Willie Thompson insisted on finding Matt guilty. According to him, whether Matt killed Joshua on purpose or not, it doesn't matter. However, Matt's act of deliberately lighting a fire in his house and then letting Joshua burn to death was a mistake. Finally, the trial found that Jacob Matthew Morgan was found guilty of murder and arson. First degree. He was sentenced to 30 years in prison. However, it will be released again after 15 years of trials. Well, in my opinion, in this case, it is not entirely Nate's fault, but also due to the negligence of his parents who left Matt's sister at home. If this case happened in Indonesia, Matt will probably not be sentenced as severe as death, and also because there are legal provisions in Indonesia, namely people who are not given responsibility for the law are like crazy, people who forget their memory, as well as autism. Law enforcers will analyze the case that informs the parents the truth of whether the child is truly autistic or not, so that in the end it can be seen whether the child can be punished or not. So guys, that was a case I brought for this presentation. If there are many mistakes of speech and words, I apologize for as much. Thanks. Assalamualaikum warahmatullahi wabarakatuh.
He has to take responsibility. And so there's much more here than probable cause. So I ask the court to find probable cause in both charges in this case.
All right, thank you, Mr. Thompson. The testimony, existing on both sides, question testimony. I believe the state has, in fact, met their burden. So therefore, I am going to find that there is probable cause to charge the individual with the bound over for General Sessions Court for both charges.